some key takeaways, the points you'd like to make to leave with the audience. So, Michael Hefter, we're going to start with you. What are your key takeaways for the event?
One of my key takeaways is in advising a client who is pre-litigation planning over a commercial contract, don't get into and you think you're going to be the defendant defending a lost profits claim, don't get lulled into a false sense of security by a consequential damages bar in the contract. In many cases, your clients know that litigation may be coming down the pike. They may have retained you several months, if not longer, beforehand to analyze the legal issues that may come up in the litigation. And I think depending on the specific language of the provision in the contract, you may have to advise your client that it is not as ironclad as the client may have thought it was at the time that the contract was entered into. That's one. And two, if you're prospectively looking at a commercial transaction and negotiating a commercial contract, then I would look very closely at the proposed language in the consequential damages bar to make sure that it aligns the party's intent with respect to barring lost profits claims, if that is in fact the intent of the parties.
Thank you for that, Michael. Eric Macy, you're next. A minute or two for some key takeaways, please.
Sure. Two things. One, the most important thing with your expert is to ensure that his or her methodology is sound. I just finished a 1-week arbitration in the prior month on a trade secret dispute. The arbitrator awarded, my client was the defendant. The arbitrator found that there were some limited trade secrets that had been taken. However, that there was absolutely no basis for the claimant's claim for lost profits in connection with taking the trade secrets. So, they won the war. They won the battle and lost the war. And my client was ecstatic. So the methodology is huge. It has to be reliable. And the one other piece of advice I really, really want to give after doing this for 41 years, there's a great tendency for people to be focused on their entire cases on liability, that it is kind of like the God of what I'm doing. Liability. They'll spend huge amounts of time and dollars for that. And they wait till the end of the day to get a Greg and to talk to a Greg late in the case. And I strongly urge you, in any kind of case, a commercial case where lost profits are involved, get that expert in early to get an analysis of lost profits so you understand what the real potential value of your case is, either on the upside or on the downside if you're a defendant. Thanks.
And thank you, Eric. And finally, Gregory Smith, some key takeaways from you. Take a minute or two, please.
Okay. Well, and just to add on to what Eric just said regarding considering damages earlier in the case, I'd like to make a pitch that for experts getting involved earlier, not just because it gives you an idea of the value of the case, but also because, if we get brought in too far down the line, we may not be able to get all the data that we would ask for through the discovery process. The data is, critically important in developing a reasonable model. So that's another reason to give that some thought earlier in the case. To sum up, I think, in developing a lost profits model, the first and I think perhaps most important step is to translate the legal theory into the economic impact. It can be relatively straightforward, like the restaurant lease. It may be more complicated, but that sets the stage for building your model. There are a number of methodologies you can use, but they all have to be solid and they have to be appropriate for the facts of the case and the data that's available in the case. Once you've been able to estimate the lost revenue, the but-for revenue, usually the costs are a little easier to pin down, but you have to do that with a solid approach as well. And, because a lost profits model compares what happened in the real world with a but-for or a hypothetical world, which did not actually occur, you really have to develop each component to be supported with sufficient relevant evidence and analysis of that evidence to get to the concept of reasonable certainty that we were talking about.